Hello, YouTube. Welcome to a brand new episode of AskReddit. Lawyers of Reddit, what was the best gotcha moment you ever experienced? Lady got into a minor fender bender with a truck in a casino parking lot. She backed out of a spot into him. My guy said she parked and went inside the casino for a few hours. At her deposition, she testified that she was so hurt she went right home into a hospital. I asked if she was a frequent visitor of casino, and if she had a rewards card. She was happy to tell me she did and she had gold status, and showed me the card. I subpoenaed her rewards card's records, and it showed she was playing slots for hours after the accident. Plaintiff had an X-ray of an allegedly broken arm. It seemed off to me and the dates didn't make sense. I was in-house at an academic medical center. I looked at the case more closely and discovered the plaintiff was an X-ray tech at another hospital. After that, it was all over. My client's house burned down from an explosion in the fuel oil tank used to heat the house. It was clearly the oil maintenance company's fault, but his homeowner's insurance, from a very reputable company, still refused to pay out, citing a ridiculous technicality in his policy. Essentially, the policy covered damage caused by the oil heater, but they claimed that it was the storage tank that exploded and wasn't part of what was covered. So they deny his claim, which was about $1.2 million, and then I get involved. During a deposition with the claims adjuster, I asked how she came to the conclusion that the storage tank was not a part, or at least connected to, the heater. She states that she relied on her expert witness who was an engineer. Little did she know I had already checked this person's background. He had zero engineering experience or education. As most of you might know, you don't get attorney's fees in most cases. However, when an insurance company denies your claim in bad faith, now you do. Her little admission cost the company about $500K in fees, on top of the original claim for $1.2 million. And this is why so many people try to screw insurance companies. Because they're right there, trying to screw you too. Plaintiff alleged he was so injured in an auto accident that he couldn't work, do any regular activities, or pick up his young kids. He then posted on his public FB profile him doing the ice bucket challenge. If you're not familiar, he basically lifted a huge cooler filled with ice water over his head. His attorney had no idea he had posted it. Once heard about a man who got a doctor to do him a report for his compo claim, can't bend, can't lift, can't run, etc. Problem was, he had a paternity suit ongoing at the same time. Got the same doctor to write a report for that case, no restrictions on mobility, can pick up the kid, play with him, etc. As you can guess, he, and the doctor, got caught. I was trying to get a restraining order for a woman in DV court from her son's father. We are presenting testimony and she details a story where he grabbed her arm and slammed it on the tub, breaking her wrist. On cross, I asked the accused if he ever broke my client's wrist on purpose. His response: yeah, I did. She was 9 months pregnant, about to smoke crack and wouldn't stop. I tried to grab her arm to get the pipe and protect my unborn son. F me. She left that detail out in her conversations with me. I had a former client file for bankruptcy and in connection with that case brought an action against his landlord for violating the automatic stay. In order to prove damages, he wanted to show he paid my firm for illegal fees in connection with the landlord's pursuit of rent in violation of the stay. So this former client's bankruptcy lawyer serves me a subpoena to show up at the bankruptcy hearing. He didn't ask me any questions prior but just gave me the gist of what the objective was, i.e. verify with the court the time I spent and the cost to his client. The bankruptcy attorney called his client, my former client, to the stand first. He asked him questions related to his hiring my firm to do this and that, as it related to his landlord. Apparently that's not enough. The bankruptcy attorney wants me to verify these facts as well. I get put on the stand and I'm asked to verify the invoice. I first object to the question as a precaution, since it may be a violation of attorney-client privilege to answer the question and to cover me for any claim by the bar or my former client. As predicted, the judge overrules and orders me to answer. I review the invoice, answer: no, this is not my invoice. His attorney: I don't understand, this is your firm's logo and information, right? Me: yes. His attorney: and you provided these legal services, right? Me: no. A very confused attorney slowly started to put together, after a couple more follow-up questions, that this idiot client of ours had manufactured my invoice to prove his damages. Needless to say that I could have given his new attorney the heads up, but I wasn't going to help someone who had committed perjury to the court using my name. I had represented him in a completely different matter, and this guy was trying to make some extra cash through this bankruptcy hearing. 2 lessons: tell your attorney everything, and as an attorney, make sure your client feels comfortable to tell you everything. Not a lawyer, but when I was in the military I was accused of something I didn't do. And I had to go to court over it. And during court the prosecutor started to detail this investigation and how they had staked my apartment out for months. They entered into evidence a picture of my apartment. And when they put it up I looked shocked at my lawyer. BC, it wasn't a picture of my place. It was my ex-wife's apartment. A place I had never lived, never even spent a single night there. I lived in a house, she lived in an apartment. And when my lawyer was asked if she objected to the picture being entered into evidence, she replied, "I don't mind them entering it into evidence as long as they change the listing of it." And when one of the members of the panel, no judge, 3-member board, asked what was wrong with the listing, she looked at him and said that's not his apartment. On top of this, the witness they used against me described going to my house on the night in question, and she named the subdivision where she had visited me, except that wasn't where I lived either, also wasn't where the picture they had was either. Case was dismissed and I was told they requested the witness to return to answer questions about perjury. Lamau, when you investigate the entirely wrong house. Someone getting fired. Dude, you have no idea. The funny thing was, when they brought me in to question me, they had this huge folder full of their evidence and I was just like, WTF is going on in there? And because I wasn't cooperating by confessing to something I hadn't done, they wouldn't show me what was in it. But they had to turn it over to us before court. And it was legitimately like 5 or 6 months full of entries where they had someone scoping out my ex-wife's house. And each entry said something along the lines of when they got there, how long they were there, and no contact made with subject. So they really were at the wrong house every day for 5 or 6 months and never realized it. I have no idea why they never just tailed me home from work or something. My wife had insurance through me for my daughter, so when they updated her address in the hospital computer, somehow they also changed mine as well. But this was back when phone books were still pretty useful, and my address was properly listed in the damn phone book. They just never looked. They just sat at the wrong house for 6 months and still went forward with this case that they had no evidence on. Edit. So all of this investigation and drama led to a court case where the entirety of the evidence against me was basically the word of 2 witnesses. One who never testified, and the other who said she came to my house, she was never there, in a subdivision where I never lived. I mean, that was one thing I really hated about the military, that they can just do stuff like this to you. BC, the trial never would have happened in the civilian world. Cross-examining a custom home builder who had a lump sum contract, set price as opposed to cost plus, which means cost of the materials plus X% as builder fee, with the homeowner. Claimed he put 20% more labor/materials in building the home than the contracted provided for, and he was suing for these excess costs. Was asking him about an email with my client negotiating the price of the construction, and he volunteers that he knew he couldn't build it for that price. My head snaps up, supervising partner's head snaps up, and opposing counsel goes pale. Dialogue was something like, "Me, you quoted X price?" Builder, "Yes, me, you knew you couldn't build it for that price?" Builder, "Yes, me, you knew the homeowner was relying on that quote?" Builder, "Yes, me, you knew homeowner wouldn't have signed contract without that representation?" Builder, "Yes, me, and you told homeowner's lender you could do it for X?" Builder, "Yes, me, and bank relied on that price and wouldn't have given loan if knew it was wrong?" Builder, "Yes." This is textbook fraudulent inducement and he had no idea. Builder got poured out in the arbitration award and slapped Builder with sizable punitive damages on top of it. 5 minutes of testimony sunk his case because he volunteered information without being prompted. Edit. Thanks for the correction/you/new Luna. The first case I ever did, opposing counsel misplaced the copy of my client's driver's license. Rather than admitting his mistake and asking me to resend it, he filed a motion to compel, claiming we never sent it. Well, I was able to provide proof that we'd sent it to him like 8 months ago, so the judge was rather displeased with his antics. Not a lawyer, but this tends to be my impression with judges who catch people doing shady things. I remember once, during undergrad, being an intern with a probation office, and the case ahead of our revocation hearing had a guy pleading guilty. During his rambling and disjointed allocution, the judge frowned. "So why are you pleading guilty exactly?" The guy replied, "My lawyer told me to." The judge was most displeased when he questioned the guy further and found out the guy had no concept of what he was doing or what the potential sentencing could be. Sometimes, it's just incompetence. I was observing a federal case 2 weeks ago. In the opening statement, the lawyer had a PowerPoint presentation that looked like something a high school student made. It was filled with clip arts, powerful, but irrelevant, pictures that evoke feeling like handcuffs, jails. The judge stopped him, sent the jury away, and asked the lawyer, "You realized you cannot present arguments in an opening statement, right? Do you have any other similar visual in your presentation?" The lawyer said no, and the jury was called out again. Presentation continued, but there were more pictures, so the judge had to stop him again. This time the judge said, "You clearly had no understanding what is allowed in an opening statement, so I'm just going to disallow the presentation altogether." There was a few more times the judge had to call the lawyer out in that case, but ultimately his side win. It was a very odd case with so much mistake by that lawyer. Thank you for watching. If you liked the video, like, comment what other subreddit you will like me to do, and subscribe.